Okay, our next program is going to be dealing with social media and collective bargaining, which is an interesting combination, but I think you'll appreciate it. Thrilled to have Jonathan Downs here with us. Jonathan has over 30 years of experience in practicing labor and employment law in Ohio, and he's successfully negotiated over 500 labor agreements and has presented over 100 impasse proceedings, 100 arbitrations. He represents cities, townships, counties, school districts, and public officials throughout the state of Ohio. He also represents private employees in employment matters. He's argued before the state Ohio Supreme Court and the United States Court of Appeals in the Sixth Circuit. Jonathan is rated AV Preeminent by Martindale-Hubbell. You might have to tell me what that is, I'm not sure. Jonathan is a fellow of the College of Labor and Employment Lawyers. He's been selected as the best lawyers in America, employment law, labor law every year since 2010, and as an Ohio super lawyer every year since 2004. One of Central Ohio's top attorneys since 2009, and he received the Opelra Award of Excellence in 2016. He is also certified by the Ohio Bar Association as a specialist in labor and employment law. He lectures frequently on many topics, including state and federal employment law and labor law development, civil rights, civil service, arbitration, and collective bargaining. Jonathan served on the Civil Service Review Commission for the state of Ohio, authored Civil Service in Ohio, and edits the Westlaw annual publication in Ohio Civil Service and Collective Law Rules Annotated. Jonathan was a member of the OSBA's Board of Governors for Labor and Employment Law section and is a member of the Ohio Management Lawyers Association and a charter member and past president of the Ohio Public Employer Labor Relations Association. Jonathan volunteers in his community in various capacities, including serving on boards of a public library and 2 charter schools, and advises a high school mock trial team. What they don't tell you is Jonathan is also very generous. He's very happy to come out and support the community and public service and does a lot of these local presentations without charging any fee. I've been working with Jonathan now probably 20 years. He does a lot of training for our organizations. He's well known in the police circles. He teaches at the Ohio Police Chiefs Association, all kinds of stuff. So he's got a wide variety of information, and I think he's going to be able to enlighten you with some of his topics. So there you go.
Great, thanks. So the first thing I want to tell you about you as an audience is thank you. I appreciate what you do for your communities, for those you have elected, for those of you who are paid. You're also working in an environment that's extremely challenging. Politics is politics. It hasn't changed. I'm reading a book about former presidents and the vitriolic exchange between Jefferson and Madison and others, and then John Quincy Adams and Jackson didn't get along as well either. So if you read what they wrote 100 plus or almost 200 years ago, it really hasn't changed. It just comes out faster. So that's what I see, and we get a lot of that in the world of labor relations. I want to tell you with respect to the social media issue, that's a big issue for us in terms of employment issues, but also political issues, because the unions will use the social media a lot as well. This PowerPoint is yours. Star has it. If you want this as opposed to having to write stuff down and you see stuff on here that you want, Star will send it out. This belongs to you. I came here today. I don't copyright my materials. I will tell you, in my world, plagiarism is a high form of compliment. I don't need credit or anything. If you find something on here that you like, great. You can thank Star for that. So I want to do a couple little things. There's the propaganda sheet that doesn't have the Virginia Tech on it. When we deal in the labor world, and this, for those of you who are on city councils, this is the world that city managers, police chiefs, fire chiefs, service directors, safety directors, city managers, this is the world they have to live in. And so if you look at this just a little bit, I think you'll find it's interesting. There's a lot of litigation out there. That's what we like as lawyers, obviously. We deal with discrimination issues, retaliation issues, and then what I love to call the cornucopia of acronyms. So let's look at the cornucopia of acronyms. What's Title VII cover?
Us.
Civil Rights Act of 1964, which was based on the Civil Rights Act of 1865. ADA means what?
American Disability.
Right. And ADEA? Anybody with no hair? What's ADEA? Jesus, criminy. Age Discrimination Employment Act. FMLA? No. Friday, Monday Leave Act. PDA. What's PDA stand for? What's PDA stand for? Public display of affection? No, but sometimes it may lead to this. That is the Pregnancy Discrimination Act. You really came here just for that, didn't you? Fair Labor Standards Act is the next one. Section 1983 is the general section of Title 42 of the United States Code under which you will get sued. And don't worry about it. Unless you went outside the lines, you're not going to be personally liable. I won't talk about that a lot. You'll deal with that when you deal with whoever handles your liability. So these are the issues that public employers have to deal with. Fair Labor Standards Act, the overtime law became effective a few years ago, actually 1985, Garcia versus San Antonio. So these are the major issues. When you start to listen to what your city managers or mayors who are talking to you about, or police chiefs, these are all the things they have to consider. This is the checklist. When someone calls me, this is my mental checklist. So let's move right into social media policies. Lots of litigation here, lots of litigation. One of the things that lawyers just drool over is the idea that we get to handle a First Amendment case. I mean, this is nothing better than that. It's the First Amendment, free speech, fact patterns. We get to really, really go over it. However, we have a couple of great cases out there that explain what you can and cannot do, both as an elected official, but also for employees. There's a lot of litigation out there on employees, what employees say or do. So if somebody you vote on a certain way in a particular issue, you get slammed on social media, right? Yeah, what's going to come? That's why everybody in here has thick skin. Or you wouldn't be where you are. You are in positions that are subject to criticism, a lot of criticism. So what do we look at? What is the social media policy that your jurisdiction has now? What does West Carrollton have? What do you know? Do you have one?
We do have one.
You do have one, uh-huh.
Verbatim.
No, I'm not asking you to memorize it. Can you find it?
Yes.
That's the key issue. Can you find the social media policy? Because there's a couple kinds of social media policies. One for you as an elected office holder, one for you as a person who works for the city, and one for him as an employee of the city who can criticize the city, but only so far. And I'll show you a couple cases on that. So reviewing the policy, and I think currently, because there's another Supreme Court case pending, the one we'll talk about that just came out very recently, but there's another one in the pipeline right behind it. And I'm not going to predict what's going to happen there because you shouldn't predict Supreme Courts. The policy should be updated or reviewed on a regular basis. If your city administration hasn't done that yet, after the case that I'll show you here in a couple of minutes has been issued, they need to go back and look at it again. And I'll show you the points from that case as well, because the social media is how we get our information out. This is the town crier of the 16th century. This is the Gutenberg Bible coming out and printing stuff out so you can read it. But now it's all out there, and it's out there fast. And how many of you have your cell phones on where you have alerts that come up? Everybody does. And there's a lot of issue there. The key issue on the policies for you is making sure that there has some as a city, that there's some precise natures to. We've got to be careful with vague and overbroad policies. And we have a Sixth Circuit Court of Appeals decision on that, Marquardt versus the City of Cleveland, involving an EMS captain. I'll get to that later. But the court found the conduct of the individual despicable, but also said that the City of Cleveland's social media policy as it applied to employees was overly broad. So we're trying to find out where the fences are on this, where the guardrails are on this, and the recent decision that came down involving a city manager out of Michigan that stayed up north. We'll make sure that you have those as well. So those are the key things. Looking at it, I love this. This is great. I have the freedom of speech, and don't take it away from me. And this is a core concept of where we are. If you want to look at going back to your political science 101, this is democracy. This is what we have that many others do not. And I will strongly defend that until you step over the line. And if you stepped over the line, I'm defending you, then I'll argue you never stepped over the line. So here's the case. Linkey versus Freed. I'm going to walk through this very slowly because This is the one that lays out what the standards are. In my opinion, what the Supreme Court did for us was outline the standards that many of us thought were already out there, but this is a really interesting fact pattern, because when they come to, and you'll see it on the next slide, COVID brought us many things. It brought us the ability to understand how social media works. For some of us, how to do virtual meetings. I can't tell you how many conferences or presentations I made during COVID on a virtual basis. I know I did one for MVMRA on the laws that came out back then, and you remember it, Wayne, clearly in your head, the FFCRA. You remember that one, of course. But there were a lot of things that were coming out. So we learned a lot about how we were doing things. And so when you had to work from home because you needed to shut down, as the city manager did here from Port Huron, he also had a private Facebook posting. He also had a private Facebook. Is he entitled to have one? Absolutely. It's called freedom of speech. Should you have one? That's a policy decision of a particular jurisdiction. So Wayne, do you have a private Facebook?
No.
Why not?
I'm stupid when it comes to social media, and by stupid I mean I don't get involved.
Well, stupid on social media is the same as saying something stupid in front of a whole bunch of people, like I could do right now. But
I just did.
yeah. It suffered you for how many minutes? So we're looking at social media as another medium, and it's one where a lot of information is pushed out, where you have it. So there's multiple kinds of social media. Facebook for now, it'll be something else later, but it's electronic means. So Mr. Freed is sitting at home, and he's posting about COVID, and someone criticizes him about what he's posting on his private Facebook. What do you think? Can he do that? This is a city manager. This is the Wayne of Port Huron. Can he do that?
I mean, he can, but is it?
Okay, yep, very good answer. And then we got.
Is it ethical?
Is it ethical? Okay, we'll get to that point depending on what he says.
Absolutely.
Okay, so let's go a little bit farther than that. She's brought the question about ethical. What's the other question?
Whether he would be a representative of the city or not.
Bingo. These two tie together. So is he speaking on behalf of the city of Port Huron, or is he able to communicate? Now, when you're speaking on part of a jurisdiction, what does that mean with respect to people from outside being able to respond to your Facebook posting? What does that mean?
You have consistency and the ability to respond.
Consistency and the ability to respond. What else, Tom? I love name tags, by the way. I'm John. What else? What else, Tom?
When they become a public record.
Okay, good. What else? You don't go on Facebook? Well, just pretend. Just pretend. Just pretend. What else? What happened in this case? If you have a Facebook for your city, which city was, sir?
West Carrollton.
Does West Carrollton have a Facebook?
They do.
Do they have one for the police department?
I'm not sure they have it. They have it for the
I'm going to come to that. I'm going to come to that in a minute.
the fire department. They have it for the city.
They have it for the fire department, city. Look around, see what you have on Facebook. You all need to know that because the information comes into the city from people who are posting on your Facebooks, okay? So you gather a lot of information. I want to talk about that a little bit more. But he was blocked. Did you know you can block people from posting on your Facebook? So what's the difference between, Wayne didn't know that, by the way. So what's the difference between a private citizen posting and blocking and an elected official posting and blocking? What's the difference? And government business, government action, public record, free speech, privacy, good, but whose privacy? Now this really isn't a new case, and I'll show you in a couple minutes. There's a guy named Trump who plowed some ground on this one several years ago. All right, so the two-part test to determine whether or not a social media account belonging to a public official serves purposes relating to that official's duties. Because if you are posting in your official capacity versus your personal capacity, you can block someone or you cannot block someone. If you're in your personal capacity, you can block someone or you can take down their post. If you're in your official capacity, you cannot, except by the policy that you have. And your policies that you have for posting on social media will have several criteria in that, and we'll get to that. So you have to be very, very careful. So you may not like or appreciate the posting that someone puts on the city Facebook or website, wherever you allow citizens to post. But if they're posting on the official website, they have it's town square, it's the steps of City Hall. Take your pick of analogies, and you have to have certain rules which you can take it down. Sir.
Good question. For a personal page for elected official, does it take just one kind of posting maybe in an official capacity to then, does that become viewed as it is serving the purpose of the city? Like, say I had an account for 10 years, it's only ever been my family, my friends, I talk about sports, and I share one comment or thought on recent legislation or decision that's made. Is it from then on completely viewed as that is a public capacity page?
Great question. I'll answer that in a minute. When does your Facebook posting become public versus private? Depends. You're going to get that a lot from me, right? It depends because we're going to look at the fact scenarios. I'll show you how to keep it from becoming a public posting, and so there's some things you're going to want to do there. So you're going to have on your Facebook post. Do you have Facebook? Do you have a shirt that says City of what?
Lincoln Heights.
Lincoln Heights, the Village of Lincoln Heights. Does it say Village of Lincoln Heights? You got a logo on there? All right, you do though. But do you have it on your post? So how are you identified on the Facebook? Do you wear something that identifies you as a member of the city council, village council, etc.? Do you have it somewhere in your logos? So you can. You can do that if you want to. I don't think that's going to destroy the situation. So the two-part test. You've been waiting for this. It was the next slide. The two-part test. Let's look at it. Public official who prevents someone from commenting on their social media site engages in state activity under Section 1983 is a federal law that allows someone to sue you for violation of their constitutional rights. So it's an acronym that a reference that we make. That you possess the actual authority to speak on the state's behalf. State is a collective term of art here. So you are part of the state. So cities, counties, state industries as well. If you are possessed with the actual authority to speak on their behalf on a particular matter and purported to exercise that authority when speaking in relevant social media posts. The next three words are really interesting here. Next four words. In the unanimous decision. Everybody agreed with this on the Supreme Court. I was very pleased to see that Justice Barrett noted the disclaimer or label on a social media account or page declaring it to be personal rather than public. So you have to clearly label your Facebook as personal in order to be able to take down comments that someone posts there. Very clearly. Go back there, and what I would suggest to you is if you have a Facebook and you use it, you have a law director, have your law director look at it and make sure that it passes muster in terms of someone who's going to have to defend you on that. So again, unanimous decision, it's personal purposes or public officials owner. In this case, the court sent it back down to the court in Michigan, the federal district court in Michigan, actually the Sixth Circuit Court of Appeals, so they can look at the facts of what was on that Facebook itself. So I don't have the ultimate decision on whether or not this city manager from Port Huron had has passed the test, passed muster under this. But even if you have one now, if your Facebook posting says now nothing about whether that's personal or public, go in, put it on there. This is my personal account. Even though I am a member of a village council or city council or whatever. You need to put the word personal opinions there as well. Even if you have a logo, you're wearing a shirt that has a logo that says, I'm with the city of chaos, fine. It feels that way some days, doesn't it? Oh, by the way, how'd you all do on the eclipse this week? Did you do all right? On the eclipse? It was awesome, wasn't it? I took grandkids to a place near where the line went over. And my fun was watching the kids watch the moon. Or was that? Anyway, great things happen. You can maintain the right to block viewers. Now, I'm going to shift gears on you just a minute. You fail to keep the personal posts separate, you're opening yourselves up to potential liability. That's where you get back to your liability insurance carrier. You want to make sure that your carrier, it's not something like MVMRA. Check and see what MVMRA says about being sued for your personal comments on your posting on your Facebook where you didn't put in the disclaimers, and therefore you became working in your official capacity. The remedy is very simple. The remedy, if you don't have it posted, or your city doesn't, you're with Village, like the village doesn't have it posted, that they can take it down for a certain set of reasons, I can sue you under the First Amendment. What's that worth monetarily? Very little. So the damages here are not the dollars you're going to be paying someone. It's going to be the lawyer you pay who sued you and the lawyer who defends you. Thank you very much. We like that for you. We appreciate that. Oh, by the way, in all those laws that I mentioned back there in the slide a little bit ago, there's a section at the end of those laws. And what does the section at the end of those laws say? Have anybody been through civil rights litigation before? Discrimination law? What's the last? Wayne, you know what the last section is in all those laws, right? Attorney's fees, right? Attorney's fees, which means, said another way, the lawyer gets paid. So one of these cases come up, we advise, hey, do a mea culpa, cut off the attorney's fees, send them $1, certified mail, and get done with it. So the key thing, disclaimer, label the social media pages as a private or public. If it's a public, say it's public. If it is public, make sure that your law director, city manager, village manager has vetted it again. It's time to look at it again because of the Supreme Court case. Tom?
Whose dollar? Is it my family's dollar or is it the municipality's dollar?
Depends on whether or not you stepped over the line were willful and wanton violation. So basically speaking, it's very, very rare that the elected official or an employee of your jurisdiction are going to be personally liable. There's the Sovereign Immunity Act, Chapter 2744 of the Ohio Revised Code. You have to act in a wanton and malicious manner. And you look both wanton and malicious. It's right under his name, Tom Wanton / malicious. Yes.
Yeah, so if I go on another Facebook page,
Somebody else's.
right,
Okay.
and I make a comment,
Right.
so how do we distinguish whether I'm the council person speaking or just Laverne speaking? And I'm on another, and the comment.
Well, it's very simple. You can call yourself whatever you want, Laverne. You could say, I'm the councilwoman, village, and I'm responding to your comment. That posting can be taken down by that person.
Okay.
So you can say what you want, freedom of speech. But if they take it down, you don't have any cause of action if it's a private citizen. Now, if it's her Facebook posting, and you're calling her out on her crazy ideas, and it kind of looks that way, and she doesn't have it say this is a private Facebook posting, she can't take it down without violating this case. Does that make sense? As a policy, for elected officials, you have to decide whether or not you want to respond to Facebook postings somewhere else, or provide explanations, or send them to someone to get information or clarification, or if it's just one of those people just ranting and raving. All right, each one of you have 2 or 3 or 4 village idiots. They're all out there. They're never going to go away. There's always going to be someone out there who's going to be the negative person. All right, after this, I'm going to show you real quick, and Trump's not the only one. Right after this case came down, there's several other people who sued a whole bunch of Democrats. So this was a back and forth political move as well. So Republicans got sued, Democrats got sued, the Congresswoman from New York got sued right after this hit, and she took her post down, so the case went away. But it's the same thing. It's the same thing. It's the same fact pattern. The biggest difference here is this case only went up to the Court of Appeals. It did not go to the Supreme Court. Same standards, same. So when you move, what the lesson for y'all here is that y'all caught that. That's from my years in Virginia, at the Virginia Tech. So when you move from private to public, all right, so when did you take office? In January. Did you have a Facebook posting before? Pretend you did. Now you move to public, you're different. You're a new animal now. Your Facebook posting now needs to have this. So this is a case where it showed Trump in his private capacity, moved into the presidency, now he's in his political capacity, and is responding to someone's responding to posts that were out on his social media site. So when you all transitioned over, you are now a bird of a different color. You need to make sure, if you have one before, that you go back in and check it. And you can look at his was a Twitter account. The inauguration used it, and let me see here. I'll come back to that one. So the case citation, if you want to read it, you just pull in Knight First Amendment Institute versus Trump, and the Knight Institute looks for the issues of free speech. That's their job. That's what they do. Sir.
I would assume that, obviously we're talking about blocking certain content, so it's, if you're
Or-
public, you're basically taking a view on.
Content or people.
Right.
Okay.
But, somebody gets on your personal Facebook page and things get contentious, I'm assuming you'd still just simply delete the page in total.
You can delete the page in total. You can trash it, or you can just block them.
Well, what I'm saying
I don't know how to
is
do
you
it.
couldn't block them if you're deemed to be, basically, you're using this as let's say, a mix of public and private. You're posting some things about the city, whatever, and it just gets contentious and you're just done with it. I'm assuming that it wouldn't be a violation of any kind. You're not specifically focusing on that person, you're just deleting your page in total.
If you had on there that it was personal. Okay, so go back and check your Facebook posting. You don't lose your right to free speech because you became elected to an office holder. You still have opinions. You are free to express those opinions, but you must state on your Facebook posting or Twitter or X or whatever it's called, whatever it is that you all use. I use LinkedIn. You need to say that it is your personal opinion. Okay? So you still have freedom of speech, sir.
You start with, in my personal opinion?
Yeah, I definitely would say it in my personal opinion, because now you're also talking about the people who are going to be voting for you or against you in your next election, but this is your opinion. I like the word, I like saying in my personal opinion. I like that. Thank you. That's a good idea. I'll put it in the next PowerPoint. So these social media cases are really just an application of what we've had out there for a number of years for what public employers are allowed to do or not allowed to do. The McKnight case carried it up to the elected office holder with that, and now we have the Supreme Court decision that goes from there. I'm going to switch gears on topics because I've got 45 minutes and three areas to cover. Any other questions on that? We've taken half an hour of my 45 minutes, and I'm not going to keep you from lunch because I like to eat too. And by the way, at the end of this is my email address. If anything I say today provokes a question in your mind later on, email it to me. My responsibility to you is to respond to your questions, or send them through Star, and she'll get them to me as well. Yeah, I do these things for free. Why do I do them for free? Why do I do this for free? Because I don't want you to screw it up for the rest of us. And Lord knows, that guy in the back, I don't know. All right, this is an interesting case for internal words as well, in terms of conversations internally. I want to show you this case because people have the right do not have the right to record a private meeting of the business of the city. So if you're in a private meeting, now I don't mean where you have a quorum and now you're subject to the sunshine laws, where you have a private meeting, and this one applied to police officers in an investigatory situation. They do not have the right to record that private meeting, period. We haven't seen this case extended to other private meetings outside of an investigation of a police officer's alleged misconduct, but I think the principles apply here. They do not have the right to record you. So if you're having a private meeting with someone and you set it up, you're sitting at a restaurant or wherever, or you're sitting at your home, you're sitting in the park, I don't care. You can always ask that other person, are you recording me? And if they say yes, you say, I do not give you permission to record me. Because there's a lot of people who walk around, not this shirt, but others who have something in their pocket, right? And you turn that thing upside down, hit the right button, and record you, right? No, they do not have the right to record you if it is a private meeting. And Wayne, this is something for your police and fire folks as well. This case I've been pushing out a lot. It'll be at the OACP session in a couple of weeks. So there's 14th Amendment here. So you see I'm drooling again because we'll get back into the 14th Amendment. This is the kind of stuff that I like. But I wanted you to see this. Even though the case addressed police officers, I believe it affects and impacts any private meeting anyone in the public sector has. If you get sued on this, let me know. I want that case. I want to be involved in that case.
Does that include cameras like that are within a facility?
Yep.
A public facility?
Inside the public facility, if you're there and you know the cameras, then now you're entering another interesting world. And that world is, why is the camera there, and do you have the right to shut down the camera? Don't go where there are cameras if you don't.
Well, I just didn't know if, like, when you talk about police officer, if there was something there, are they able to use that against the?
This is where the union wanted to record the conversation.
Oh, okay.
This is where the union, if you want to record it, and the other person has the opportunity to tell you no. But if someone's starting to record you, but if you're in a place where a camera is, the camera's there.
But let's say the city has a camera at the city garage.
Yeah.
Do the employees at that point have the ability to say?
Nope.
No.
Nope.
No, they don't.
Correct.
Right.
Correct.
Okay.
You own it. It's your space. That becomes an issue between the union, and if there is a union, or the employees and management as to why you're recording it. Well, it's easy. Theft, et cetera, et cetera. The GPS systems that are on trucks and cars now, fantastic for maintenance issues, et cetera, but also to find out if they're going to the wrong place. There was a health department in a county not far from here that put GPS system in their, all of the cars that all the people were using. Their fuel bill went down by a third. So GPS is, especially the trucks that are out there, they monitor the systems, they monitor the fuel, they monitor whether or not maintenance is required, et cetera. So they're pretty fantastic, except when they don't work. Marquard was a case where an employee, you may see this, it will be tough. This was after the Tamir Rice shooting on the west side of Cleveland. There were similar things to this after the Over the Rhine riots in Cincinnati. This happens. Stuff happens. What occurred here was an employee who went out on his Facebook posting to his private friends, posting only, and made comments about the death of Tamir Rice. And they were extremely derogatory, they were extremely negative, they were racist at the very basics of that. And what really blew me away is he put these postings on his Facebook after the city sent the bill for the ambulance for Tamir Rice to be taken to the hospital. It was like, okay, 2 years later, the bill went out 2 years after the incident. 2 years. And then he posted this stuff. Employees do not have the right of freedom of speech when it impairs the operations of the city. So if you see something, say something. We're going to go back to kindergarten here. If you see something posted by an employee on your Facebook or somebody else's Facebook, or it comes to you, get that information over to the administration, because situations like this, and I have a 50-page single-spaced outline on social media, free speech, and public employees. I'm speaking at a national conference on this in 2 weeks. This is a big issue for public employers. So if you see something, say something. But this is the case in Ohio. The other part about this is to show your law director. In this case, the Sixth Circuit Court of Appeals in Cincinnati laid out what is a overly broad policy. So I talked to you about that very early on. This shows you what the parameters are on broad, overly broad. And if anybody wants that 50-page single-spaced outline, you're more than welcome to it. Send me an email and I'll be happy to send it to you. I'm going to move on because we're going to talk about what's going on with social media phenomenon, First Amendment audits. These are the people who come in and make sure you're doing stuff right. Anybody been hit with an audit? Did you ever get hit with one, Wayne? You don't remember? It's going around again, so I'm going to skip it if you all haven't been. People who come on the outside, they're the guardians of the Constitution. They want to make sure that your open space, that your public records policies there, and so forth. So if you haven't seen it yet, there's a couple other things I want to get to you. So there's my summary sheet. Every case is analyzed on an individual basis, fact patterns. Set against the standards that are out there, we need to look at who's the audience, who is it intended for, and what was said. Was the speech made internally or externally? These are the tests that we look at with respect to the speech that you are going to put out on your Facebook, but also the speech by public employees internally, and additionally the speech through your websites, through your social media that are put out through your city officials. Now, the police departments in many cities are advised to have a site where people can post information. They use it for tips. It becomes a very good way for them to get information. Typically speaking, a city's police department Facebook or website is going to be open up to people to actually post something. Do they get stupid stuff said to them? Of course, they're the cops. There's always somebody saying something stupid to the police. So that's where they're going to have a very specific policy about what can and cannot be removed. It has to be inflammatory, derogatory, or other things. That test has been worked out over a number of years, 10 or 15 years at the least. So the test of when you can remove it from a police department or fire department website or Facebook posting, that's there. That would be one where you might want to look at for your own purposes as well. But behind that Facebook posting, behind that Facebook page is a policy. There's a national firm called Lexipol, which also writes policies for police and fire around the country. Lexipol's policy is good. It's been defended. But again, we get back down to if you take it down, you have to have the reasons that match up with the criteria. That would be a good place for you guys to go if you want to get granular on this. I'm going to shift and start. How much time do I have left? You guys didn't want lunch anyway, did you?
Well, you go till 10:45.
10:45. Well, in my clock, it's only 9:20. Did you tell that I didn't spring forward? I gotta fix that thing. All right, so I'm going to shift over right now to talk to you as your role and responsibilities as a legislative body with respect to the Collective Bargaining Act. Even though you're a village, do you guys have a union? You don't have a union? Stay that way. Everybody else, I'm serious. You take city. Which city are you? Oakwood. You have a city. You have unions, right? I'm sorry. You have a unions.
Yes,
Yeah, and you pay your cops the most of anybody around.
we're proud of that.
Cross-certified police, fire, paramedics.
Yeah, I know. I've known that for about, well, I won't say how many years. Anyway, so I've been around this business for, let me put it to you this way. The law passed in 1983. It went into effect on April 1st, 1984. I was in this, and they were still smoke-filled rooms at the time when the debate went on. I was there, I watched it develop. I cut my teeth working for the state of Ohio for the Director of Human Resources for the state, who worked for Jim Rhodes, and I worked for as well. So what we saw was what's happening with respect to the responsibilities of the legislative body. This is the position that is the balance of power. If you want to go back to our Constitution, this is the balance of power issue as well between what authority and responsibility does the legislative body have, what authority and responsibility does the management have. How you get along and how you play that out, that's a matter of internal organization. But in the law, under the law, you have certain authority and certain responsibilities. One of the key issues that comes up is you have the responsibility to approve contracts between the city and the union. That is your responsibility. The management's responsibility is to give that to you in a form. It's many different ways of doing it. However you style it, it could be the issues, it could be the money, and whether or not they come to you and talk to you about negotiations before the negotiations, that's an internal issue for you. That's an internal issue. I'm involved with negotiations from day one or day last. Depends on the jurisdiction. But under the legislation, you're the governing body of the corporation, and you are the legislative body. You can see the rest of it. When matters about which there's an agreement are reduced to writing and approved by the employee organization, stop right there. If you have a tentative agreement with your union, and the administration's been keeping you up to date in terms of the progress of negotiations, my advice to you is always have the union go first for ratification. Always. I know of no exceptions that I've seen that have worked on that, because in writing and approved by the employee organization. The statute lays that out. They need to go first. Now, if you decide from a policy standpoint that you don't agree with that, fine. Then the agreement is binding on the legislative body and the employer. It has to be approved by the legislative body. It becomes the contract. It trumps civil service law. All the provisions except a very few, it trumps civil service law. Collective bargaining agreements cannot address pensions. That is a prohibited topic. They cannot address pensions, but they can address most of everything that is in the civil service laws as well for the classifications or positions that are covered by that agreement, not positions that are outside that. So your city police chief, your city fire chief, your assistant chiefs typically are out. Administrative positions are typically out. And it's different in the fire and police than it is the civil service, I'm sorry, the civilian employees. In fire and police, they can have organized to everybody up to the assistant chief and chief, or an equivalent rank of assistant chief, battalion chiefs in some places. Same thing in fire. The really bizarre thing that the fire union got through is all the employees from the first level firefighter to the captain or shift commander are in the same bargaining unit. In police, they're divided. Rank and file are in one bargaining unit, and then everybody's in command roles or supervisor roles or in a separate bargaining unit. I can get granular on that if you want at a later time. I'll sit down and explain that. But you are responsible to approve that, and the administration has to bring it to you within 30 days after the time that they come to an agreement at the table and there's ratification by the union. If it doesn't happen in 30 days and you don't like it, you lose. So you have to take action. So if I said I approve, I should say farther than that, go farther than that. You have, with those 30 days, to approve or reject what's been brought to you as a tentative agreement. And if you snooze, you lose. If it goes past the 30 calendar days, you lose. So that's one of the key criteria. I have only seen this happen a couple of times, but the key thing for you guys to remember is, why are you in such a rush? Well, the law says you got 30 days to figure it out. And push comes to shove, reject it and then go back to the table. So there are pragmatic ways to deal with this as well. If the body, you reject the submission of the public employer, which means your administration, either party may reopen all or part of the entire agreement. So there's the trap to you and to the union. They've ratified it. You reject it. You have to reject it as a whole, not just the one thing you didn't like. If you didn't like the wages, or you didn't like the holidays, you didn't like a specific issue, too bad. Your rejection has to be of the whole contract, at which point in time the whole agreement opens back up. Now, as a practical matter, as a negotiator, I will tell you, basically speaking, that you're going to say what you don't like, I'm going to go back to the table, or your administration is going to go back to the table, and you're going to work it out. Most of those TAs are going to stay over there, but it allows us then to recycle some of the issues in and out. So I've negotiated hundreds of contracts. I also negotiate the state contract. 26,000 employees are covered by that contract. At the bargaining table, we had 56 people. 3 years ago, we had that negotiations virtual. So I would describe the two screens in front of my keyboard where I was negotiating from was the Hollywood Squares of negotiations. It was a blast. It was an absolute blast. So you have cases up here. So there's another aspect that I want you to understand in a general sense. I've got a couple cases, this one and one following it, where we talk about who has the authority to enforce the contracts, who has the authority to bring grievances or arbitrations or go to court. The collective bargaining law, think of it as a silo, all right? And there aren't little gates that people can go out up and down this silo. It's one of the blue silos, right? I grew up on a farm, I get this. So you have to look at it, if it's an issue involving this, that's the place you're gonna have to go to serve. If the union doesn't like it, that's where they have to go, to the State Employment Relations Board. There are books on this. I'd be happy to go into a great granular detail, but you don't go into courts when it's an issue about contract interpretation. The courts in Northern Ohio, Eastern Ohio, and Southern Ohio, it's multiple cases. This is a nice fact pattern that lays that out. This is where they tried to go to arbitration, filed a ULP. We're getting a little bit hyper-technical, but now that we're 40 plus years into the law, we have some good guidelines to work with as well. There's not a lot open yet for interpretation. And we've had a consistent labor board, even though there are different people sitting on the board. They've been appointed by Republicans for a number of years. So the board has been a majority for about almost 20 years now of conservative board members that are been appointed by Republican governors. That's good for you, regardless of your politics. In your position as a city official, you decide on the policy issues there. Are you going to pull me?
Yeah.
This is a quick case for anybody who's a manager. If you've got a position open, the civil service law position for police chiefs or fire chiefs, so there's a lot of retiree hire. Read this case before you do that. And then drugs, I will tell you, no, they don't have the right to smoke dope. If you're a police officer or firefighter, if you have a CDL, period. Case law is out there, you're good. So if your policy is, no dope, no marijuana, any of that, your policies are good. They're going to stay good. And the law that's there now is very employer friendly. The legislature that wrote it for that purpose, that you are there to protect the lives of your citizens. And so anybody who's working in a dump truck can kill more people in one swipe than a gun can. You know that? And I've seen the dump trucks take out whole cars. And it's really sad and it's really tragic. But dump trucks and CDL drivers, same problem as well. And under CDL, there's also some federal laws out there on that as well, so they have to follow from US DOT. It gets a little complex, but bottom line on drugs, you can still prohibit it. And dispensaries, there's a slide for you on dispensaries if you care about whether or not you can prohibit dispensaries. The answer is, of course. You're the legislative body, you're in charge. I have gotten the hook. I stick around and ask questions. Depending on what's happening back on the ranch, I may have to slide out, but typically I make sure that I get fed.
Yes, we're having lunch. After Jerry, so he's on the hot seat right before.
All right. Thank you, everybody.